Hi, I'm Michelle Driscoll, Policy Coordinator with Michigan Alliance for Families. Thank you for tuning into this video about the power of notice. Let's go ahead and get started. Receiving written notice is an important right that parents have regarding decisions that are being made about their child's education. It's also an important procedural safeguard for students. Today I'm going to be talking about federal regulations and state rules about notice, the purpose of notice, when it is and isn't required, and what information the notice must contain. I'm going to discuss providing notice in a parent's native language and the difference between notice, notification, and consent. These all mean different things. I'm going to go through some timelines for notice and then going to wrap up with some examples of notice, some questions for you about when notice is or isn't required, and how to use notice when advocating for your child. The information I'm sharing today applies to children and students ages 3 through 25 who are or may be eligible for special education services. So for example, a parent of a preschool child or an adult age 22 request an evaluation to determine eligibility for special education services. For both of these age ranges, the process, timelines, and requirements for notice are the same. The Individuals with Disabilities Education Act is the foundation for special education across the country and sets the minimum requirements. States can do more, but not less. These are the IDEA sections that discuss prior written notice, the required content of notice, and requirements for providing notice in a parent's native language. While the IDEA does not set specific timelines for notice, only saying that it has to be given within a reasonable time before the action is taken, Michigan has set some specific timelines that I'm going to discuss today. These are in the Michigan Administrative Rules for Special Education, which are how federal regulations around special education services are implemented in Michigan. As I mentioned, states may have different rules, and timelines are one place in which Michigan has some rules beyond what the IDEA says. I also want to mention, as we get started, that you will see notice written in different ways. It may be written as prior written notice, notice, or written notice. Notice is formal, it has to be in writing, and has content requirements. I called this presentation The Power of Notice because notice is one very important legal requirement under the IDEA and is a procedural safeguard for students and parents. Rights and protections are found in the procedural safeguards notice. Notice protects a student's right to a free, appropriate public education, and it's a vehicle for communication between schools and parents that ensures parents are up to date as early as possible with detailed written information about decisions made for their specific child so they can ask questions. Sometimes there are misunderstandings about changes in your child's education. Prior written notice guarantees that you are kept up to date on important decisions being made. Parents have the right to agree or disagree with changes that the school wants to make regarding their child. This notice gives you the important information that you need to make informed decisions regarding your child's education. Prior written notice is a legal requirement of the IDEA. This is a protection to ensure that schools give written information to parents to explain an action that the school wants to take or is refusing to take. And there are certain times when the school must give you written notice, such as when the school wants to or refuses to initiate or change the identification, evaluation, or educational placement of your child, or to change the way that it will provide a free, appropriate public education to your child. Prior written notice is also required before requesting parental or informed consent for conducting evaluations and the first time that a child receives special education and related services. The information in the notice will help you make an informed decision about providing consent. Providing written notice to parents when required should be automatic. Sometimes the school may tell you something in a conversation or in a meeting related to the issues that I mentioned. This does not eliminate the requirement for the school to give you notice in writing with a full explanation of the action that they're going to take or they are refusing to take. By knowing when you must receive notice, when that written notice must be given to you, you can ensure that you will receive it in writing. If you don't receive the written notice, ask for it, and if the information in the notice isn't clear, ask questions for clarification. And just a reminder, prior written notice may be written as written notice or notice, and it's about when a school is proposing or refusing to take action. All the terms that I mentioned mean notice and that it's given in a formal written manner. There are legal requirements about what information must be included in the written notice. The written notice must give parents an explanation of the action the school wants to take or is refusing to take, a description of each test or record that the school used in making the decision to take or refuse to take the action. So this could be attendance records or evaluation reports, behavior or discipline records or progress reports. They have to give a reminder that parents have legal rights to procedural safeguards and how parents can get a copy of their procedural safeguards. And they must give you a description of what other options were considered by the Individualized Education Program team, the IEP team, and why those options were not chosen, and then any other reasons the school proposed or refused those options. And then they have to give you resources for help in understanding your rights. And we're going to talk more about specific examples of when prior written notice is or isn't required in just a little bit. Prior written notice must be provided in understandable language to the general public. If a parent doesn't understand the services being proposed, they cannot provide informed consent or permission for the services to be provided. It must be provided in the parent's native language or in another mode of communication that's used by the parent, unless it's not feasible to do so, which is defined as capable of being translated. If the mode of communication is not a written language, the school must ensure that the notice is translated orally or in another way in the parent's native language or other mode of communication. And there must be written evidence that the parent understands the notice and that the above requirements have been met. The notice may be sent by email if the school makes that option available. Native language for an individual who has limited English proficiency means the language normally used by the parent, the child's parents, or the individual. The language normally used by the child in their home or learning environment is used in all direct contact with the child, including during the evaluation of the child. For a person who is deaf or blind or with no written language, it's the mode of communication the person normally uses, such as sign language, braille, or oral communication. This is the Michigan Department of Education Office of Special Education model form of the IEP notice for the provision of services and programs. It explains all the required information that I just talked about in detail. Prior written notice can be given in a different written format. Schools don't have to use this model form, but no matter what written format is given to the parent, it must contain all the required information. Notice can reference parts of the IEP, but notice is its own separate document. You'll often see the notice page at the front or back of the IEP document. As I mentioned, the IDEA does not have required timelines for when schools must give parents written notice, other than saying a reasonable time before the district proposes to initiate or change, or refuses to initiate or change the identification, evaluation, or educational placement of a child, or the provision of a free appropriate public education to a child. Michigan rules provide some specific timelines. Regarding eligibility for determination, there are some timelines for when the school must respond to a parent's request for an evaluation, receive parental consent to evaluate their child, when the school must provide an offer of a free appropriate public education or a determination of ineligibility for special education services, and when to receive the parent's consent to begin providing special education programs and services to the child for the first time. From the time the school receives the parent's consent to evaluate to the notice of an offer of a free appropriate public education or determination of ineligibility must not be more than 30 school days. The timeline for the same process under the IDEA federal law is 60 calendar days. So you can see this is a situation where Michigan has a different rule than the federal rule. I'm going to talk about the difference between notice and notification. Notification is not the same as notice. Prior written notice, again, sometimes can be referred to just as notice, is the formal written document the district must provide parents when the district proposes to initiate or change certain things or refuses to initiate or change certain things. This written notice must be given to the parent after the proposed changes are discussed by the IEP team and before the proposed changes take place. Schools must still send a written notice when they have provided parents information about actions they want to take or are refusing to take in a phone call or at a meeting or as part of an informal conversation. Prior written notice gives the parent an opportunity to respond before any changes are made. Notification is less formal. It doesn't have the content requirements of notice and does not have to be in writing. Parents will receive notification through an invitation to an IEP team meeting. They may receive notification for a meeting to talk about their child's course selections, or if there's a change in a teacher or a classroom assignment, or if a school program is moving to a new location. I'm going to give more specific examples of notice and when it's required and not required in just a couple minutes. Notice is not the same as consent. Notice is the written information provided to parents to explain activities the school wants to do or is refusing to do. Consent is the process of obtaining the formal permission from parents for the school to complete those activities. Written notice is always given before consent is required. Consent means that the parent understands and agrees in writing to the activity that the school is proposing. Consent must always be in writing, and schools must clearly state the reason that the consent is being requested. Schools must inform parents that their consent is voluntary and that it can be withdrawn at any time. These are some common examples of when notice is required. These lists on the next few slides are not exhaustive. These are just some common examples that we hear at Michigan Alliance for Families. So written notice is required in the following examples related to evaluation. So prior to requesting consent, when a district says no, not now. So for example, if a parent requests their child receive an evaluation for eligibility for special education services, and the school says, we don't see any concerns, we're not evaluating now, they have to provide notice following a verbal or written request for an evaluation, and when no further information is necessary to continue eligibility. Under identification, prior to identification as a student with a disability, following a parent's refusal to give consent, and following a request for a change in eligibility. Regarding educational placement, any change of placement, including graduation and disciplinary changes of placement, any change in the continuum of placements. This includes a change in a placement to a less restrictive environment, for example, from a class for students with autism to a general education classroom with paraprofessional support. for a proposal or refusal to provide a particular educational setting, or a proposal or refusal to provide a requested special education program. Regarding the provision of a free appropriate public education, anytime the contents of the IEP are changed, changes to the IEP mean changes to that offer of a free appropriate public education. Even a small change, like adding more speech and language services or decreasing social work services or changing accommodations or modifications or removing specialized transportation from the IEP, these all change the offer of a free appropriate public education to that child. If a parent provided consent but changed their mind and revoked consent, following enrollment of a student who was receiving special education programs or services in a previous district, and when a student graduates with a diploma, and a student who had an IEP and a reevaluation was done and the student is no longer eligible for special education related services anymore. And then just some other areas, if a parent requests an IEP meeting and the school won't convene the meeting, the initial provision of special education and related services, and when a student reaches the age of majority at 18 years old and parental rights transfer from that parent to the student. So prior written notice is not required for general screenings that are not evaluations, observations, progress evaluations on annual goals, changes in a classroom teacher, a course assignment, or a change in a school building location, following general or informal meetings that don't result in a proposed or refusal related to identification, evaluation, reevaluation, or placement, or a free appropriate public education to the child, or to excuse an IEP team member whose area of the curriculum or related services is being discussed. So now that I've reviewed some information and given you some examples, let's consider these questions. Is prior written notice required if the school finds a student ineligible for special education services after a 3-year reevaluation? Prior written notice is required if a school finds a child ineligible for special education and related services after a 3-year reevaluation. The school must explain what evaluation procedure, assessments, records, or report was used as the basis for this decision, and that the child has protections under the procedural safeguards. The school must consider the effect of exiting the student from special education services and how that removal will affect the child's educational progress. The IEP team should consider whether the student's instruction and overall special education program have been appropriate as part of this process. If you disagree with the school's decision, dispute resolution options are available. Is prior written notice required if a parent asks for their child to spend more time in a less restrictive environment? Yes, any change in placement requires prior written notice, even if the change is moving a child to a less restrictive classroom. The IDEA says, to the maximum extent appropriate, children with disabilities are educated with children who are not disabled, and special classes, separate schooling, or other removal of children with disabilities from the regular educational environment only occurs if the nature or severity of the disability is such that education in the regular classes with the use of supplementary aids and services cannot be achieved satisfactorily. Is prior written notice required after each meeting in a series of meetings? No, prior written notice is not required after each meeting in a series of meetings if nothing changes in the IEP. But if after the end of the series of meetings, it is determined that there will be additional evaluations completed, or there's any change in the offer of a free appropriate public education, including change of your child's eligibility category, the child's placement, or eligibility for special education services, then prior written notice is required. Is prior written notice required if a parent requests an IEP meeting to discuss adding additional therapy services into the IEP and the school says no to the request? Yes, prior written notice is required if the school will not convene an IEP meeting to discuss adding services that the parent is requesting. The school needs to give written notice if they refuse to take an action that a parent requests. That written notice must include all the required components about why they're refusing the parent's request, what information that they used in making that decision to deny the parent's request, and where parents can get information about IDEA's laws and a copy of the procedural safeguards, as well as explaining other options that were considered and why those options were not chosen, and any other reasons that the school refused the parent's request. Is prior written notice required if the cognitive impairment program a student attends moves to a different location? No, prior written notice is not required if a program changes to a different location. Change in a building location is not the same as a placement change. The provision of a free appropriate public education and the placement stay the same for that child. Is prior written notice required when the school refuses a parent's request for an independent educational evaluation? An independent educational evaluation is an evaluation that a parent requests that is independent of the school district after they completed an evaluation on the child and a parent disagrees with the evaluation results from the school. Yes, prior written notice is required if the school refuses the parent's request for an independent educational evaluation. The school has to give notice and has to file a due process complaint and request a hearing to prove their evaluations are appropriate. Is prior written notice required to excuse a required IEP team member from attending the IEP meeting? No, prior written notice is not required if an IEP team member cannot attend the IEP team meeting. Required IEP team members must attend the IEP meeting. They may be excused if the parent in writing and the school agree to the excusal. The IEP team member must submit a written report to the parent and the IEP team before the meeting to be used as input into the development of the IEP. Is prior written notice required when the IEP team agrees to make a small change to an IEP with an amendment? Yes, prior written notice is required if there are any changes to the IEP through an amendment, even if the changes are small and even if an IEP meeting is not convened. The amendment does not change, replace, or extend the current IEP annual review date. So now that we've talked about notice, its requirements, when you should receive it, and we went through some examples of when it's required or not required, let's talk for a minute about 5 options if you disagree with a decision about your child's education. They range from informal to formal processes. The first option is having an informal meeting. This tool keeps people closest to the problem working together to solve it and can be the fastest way to solve problems. If a conversation has been happening between you and the teacher or the therapist and you're not able to resolve the issue, It might be helpful to discuss it with a principal or special education administrator and have them join in the conversation with the teacher or therapist. You can go up the chain of command to work on getting the issue resolved. Informal meetings allow you to discuss your concerns and issues relating to your child's education with the IEP team. And you may want to review or revise your child's IEP as needed. You don't need to wait for the annual IEP meeting to do this. Another option is a facilitated meeting. This can be any structured special education meeting, including but not limited to an individualized education program meeting, an IEP meeting, an individualized family service plan meeting, a manifestation determination review about discipline and placement, or a meeting to address behavior concerns. The neutral third-party facilitator can keep the discussion focused on the student's needs, address and diffuse conflict, and make sure that all voices at the table are heard. A third option is mediation. Mediation can help resolve disagreements related to the student's educational program, including topics that aren't specified in the federal special education law, the Individuals with Disabilities Education Act, such as communication. During mediation, a neutral third-party mediator guides a confidential discussion of the issues. The desired outcome for mediation is a written agreement that is legally enforceable, but whether there is an agreement reached or not depends on the participants. If an agreement is reached, the written agreement addresses how the issues will be resolved. Facilitation and mediation are both voluntary, so both the school and the parent must agree to participate. A mediator or facilitator can be provided for free through special education mediation services. Mediators are trained in special education law, and facilitators and mediators can be found through your local dispute resolution centers. The next two options are more formal processes: state complaint and due process complaint and hearing. A state complaint is a written statement alleging that the school district has violated state or federal special education rules or regulations. Therefore, their determination will be about whether the district was in compliance or not in compliance. It's not about right or wrong. From the date the complaint is received, the final decision must be issued within 60 calendar days. The Michigan Department of Education Office of Special Education will investigate, typically through documentation and interviews, to reach a final decision. If the final decision includes violations, a corrective action plan must be developed to address the violations. There is no appeal to the final decision for a state complaint. The most formal option is a due process complaint and due process hearing. A due process complaint and hearing address issues related to identification, evaluation, eligibility, placement, a free appropriate public education, and a manifestation determination review decision about discipline and placement. An administrative law judge is assigned. A resolution meeting is required unless the parent and the school district agree to waive it, or the school district files the complaint. The administrative law judge will conduct an administrative hearing. There will be witnesses who will testify under oath and can be cross-examined. Parties will present evidence, exhibits and documents, and make opening and closing statements. The school district will be represented by their attorney. Parents can be represented by attorneys, but they don't have to be. The administrative law judge issues a written decision and order, and with a regular due process hearing, the decision and order are issued within 45 calendar days following a resolution session. So you can see that the more formal the process, the further you get away from the people closest to the problem working together to resolve it. The more formal process, the longer the time frame for resolution to be implemented. Each of these options has a place for resolving disagreements. You just want to be sure that you're using the one that serves your child to get the best resolution. So to wrap up, written notice is a legal requirement under the IDEA and part of your procedural safeguards. It is best practice to put your requests in writing if possible. If you need an IEP translated to meaningfully participate in your child's IEP meeting, make the request in your native language. Document important process timelines for which the school must give you written notice. And if you don't receive that written notice, ask for it. Keep written documentation of verbal conversations in which the school says they will do something or will not do something. Notice must still be given even if something is proposed or refused verbally. Know the required information that should be included in notice that's provided to you, and if the information is not clear, ask questions. Schools don't need to use the model form to provide written notice, but all that required information must be provided in writing. Know that you can utilize dispute resolution options if you disagree with an IEP team decision. If you have questions about your child's education, please reach out to your regional parent mentor. We are here to support you.